We discussed offer letters in a previous video, so I'll give you an overview on these because, again, they're sort of one of the basic building blocks of how someone is hired. So, when you meet up with someone and say that, oh, you'd be a great fit for working with me, and then you identify that this person should be an employee rather than a contractor, after that, you just have them get started, right? Well, I mean, you could do that, or you could take it from a more technical perspective and dot your I's and cross your T's. And before they start working, you send them an offer letter. And so an official offer letter will have a lot of the technical things written into this about how your relationship works, start date, the amount of money that you're paying them potentially. And so we're going to talk about what offer letters are, what offer letters aren't, and what the general basic requirements are for things like this. So most employees hire the majority of their workers without formal employment contracts. Federal and most state laws don't require specific contract terms to be written down. But even when not required to do so, most employers memorialize the terms and conditions of employment with an offer letter that's signed by the employee that contains the key terms and conditions of employment. So even though technically you don't have to do all of these things, you don't want it to turn into a he said, she said process where someone thinks that you're paying them $20 an hour and you're actually paying them $10 an hour. And because of some misunderstanding, a month in, when you send them their first check, you have some sort of falling out or disagreement. Because oftentimes, disagreements and falling out are what lead to legal problems, and they definitely lead to business slowdowns and business problems as well. So you want to be very, very clear, avoid misunderstandings when it comes to money, when it comes to people's time. People are constantly and consistently having misunderstandings. So the offer letter is something that can get rid of that. Additionally, there are some exceptions to the fact that you don't have to give people things in writing. For example, some states require employees who are paid on a commission basis to have those terms about what their commissions are written down. So, for example, California and New York require commission agreements to be in writing, and they require them to contain specific information. And of course, this makes sense because the employment relationship that will have the highest level of misunderstandings is if somebody is paid by commission. And so if they don't really make very much money per hour or nothing at all, but they do make money through bonuses that they get from selling, state governments have a very, very strong interest in making sure that those people who get paid commission are being paid fairly. After they put in time for a month selling things, they want to make sure that what you talked about initially about how much they would get for selling these things is what actually happened. And so putting that stuff in writing is a way to do that, and you should check your state's own specific rules about those types of agreements. Additionally, many states now require employers to notify their employees at the time of hiring of their rate of pay and the regular payday. And so, again, this doesn't mean that you need an official formal offer letter or a formal employment contract. It just means that there are now states who require that people get this information in some way in writing. But the idea is that an offer letter, particularly a formal offer letter that meets a lot of the requirements of your state, solves this problem in one place and gets the employment relationship off to a good start by telling people what the rate of pay is and when they're going to be paid, such that there are absolutely no misunderstandings. So here's a list of all sorts of things that can be in your offer letter and are typically in the offer letter. So the title or position. So it's, what is this position going to be called? It's a much different thing if someone thinks that they're going to be called an executive or a vice president, and they're actually in their job description or position being called an executive assistant or an office manager or an office assistant. And so it's important that you clarify what someone is going to be called, what they can call themselves on your resume, what you're going to call them if they ever get another job and want to ask for a reference, because these little misunderstandings about what kind of position this person has, even if it doesn't even have a relationship with how much money this person is being paid, this can cause a lot of problems. Reporting relationship. So who is their supervisor? Who's going to manage them? Who do they report to with the information that they have? Do they report to anyone? And so, again, laying all of these things out ahead of time in an offer letter initially before the person starts work is the best place to take out the kinks out of that, because assuming that this person thinks that they're autonomous and that they don't report to anybody, but really they have to have all of their decisions signed off by you and someone else, this could turn them off or could change their mind about whether or not they want to take the job. And you want them to change their mind early on rather than later, before you both are in a relationship that you realize that you don't like. Start date. So this is important because it lays out when the money that you're paying them starts accruing, and when you need them. And so there's no misunderstanding about whether or not you actually needed them on April 1st and they wanted to start on April 16th. There's also no misunderstanding about if you pay someone $5,000 a month, for example, and their official start date is the 15th, well, then they're only owed half of that. They're only owed $2,500, because if they assume their start date was the 1st, but they didn't actually do any work till the 10th, they might assume that they're getting paid all of the money that they're all $5,000. Term of employment, if any. So as we spoke about before at great length, most employment relationships are at will. And so in your offer letter, you should reiterate the at will nature of that employment. Or if you want to hire someone for a fixed term, then you should describe what that term is in the offer letter, so there's no misunderstandings about how much or how little this person is locked in. Rate and frequency of pay. So you need to make sure that a person is paid for all the work done. And so typically that happens at a per hour rate. And so you enumerate how much this person is being paid. You enumerate how many times they should expect to get a check, typically twice a month for employees, but that can change. Manner of pay. Salary, wage, commission, bonuses. And so we'll get into all of the different ways that you can pay someone that aren't hourly, like salaries, commissions, and we'll also get into minimum wage and overtime later on. But for now, just know that the offer letter should describe in great detail, at least, what the manner of pay will be. Hours of work. And so full-time and part-time aren't necessarily significant distinctions always. So full-time and part-time are less important than how much this person needs to work. And so typically people in the United States work a 40-hour work week. That's the standard work week. And so if this person is expected to work a minimum amount of hours, you should lay that out in the offer letter. At the same time, if this person is capped to working a maximum amount of hours, you should definitely let that person know too, because the worst thing that can happen is that you can only afford to pay a person 20 hours a week, but then they end up working 40 hours a week. And so with an employee, as you'll learn later, you can't just unilaterally take away an employee's money that they earn once they earn it. So even if they earned it, even if you told them only work 20 hours a week this week, in person and then they work 40 hours a week, you can't take away their money that they've already earned. You can reprimand this person or you can fire that person, but you can't necessarily, it's very, very difficult to take away that money. So overall, laying out the maximum amount of hours per week someone should work in the offer letter is important. You may not give out benefits, but you may. So laying out in the offer letter whether or not they'll be eligible for benefits, talking about whether or not it's going to be described to them in a separate plan, and you'll give them the documents later, telling them if they're not eligible for benefits right now, when they will be eligible for benefits. That sometimes happens within 6 months or 1 year of employment. Conditions of employment. And so at every step of the process, you're trying to maintain the fact that just because you make an offer of employment doesn't mean that you're completely committed until the first day of work and everybody is completely satisfied with all of these terms. And so there are some things that you're going to need to make sure that this person is in compliance with. And we'll talk about these more later, but I-9 compliance. So are they allowed to actually work inside of this country? And once you collect these documents, you figure out whether or not they are allowed to work. And if they're not, then they're not actually employed, even though you sent this offer letter. Successful background check or reference check. And so you might ask for references, or you might do background check, or you might do all sorts of other things to figure out whether or not this person should be a good employee. And so you should make sure that your offer letter says something to the effect of you need to make sure that you pass these things to our satisfaction before you're an employee. So just because you get an offer letter doesn't mean that you necessarily can accept that offer and begin employment until all of these conditions are met. And so signing the confidentiality agreement, non-compete agreement, etc. We'll talk about what these agreements mean later on for employees. And finally, a confirmation of your at-will status. And so an offer letter, again, is another good time to expressly say that we can hire you or fire you for any reason or no reason, and that it's at will. Unless a specific contractor collective bargaining agreement forbids it, the employer generally may make prospective unilateral changes to an at-will employee's terms or conditions of employment, such as wages, bonus payments, or commission structures. And so the good thing about at-will employees is that you can tell them they're going to make more money next month. You can tell them they're going to make less money next month. You can lower their wage. You can raise their wage. You can make them eligible for benefits in certain situations, and you can take those benefits away as well. And so unless your employment contract forbids it, or if there's a union collective bargaining agreement that prevents it, and we'll talk about unions a little bit more, but typically they don't really affect the types of people who I work with and the types of people that you are, who are probably startups or independent creators. Unless either of those are in place, then you should know that the employment relationship is really flexible. That's from a technical standpoint. From a practical standpoint, if you are paying someone one amount and then the next month you tell somebody you're paying them a lower amount, well then, even if it's a very small decrease, it has a huge effect on morale, and it has a huge effect on the way the employee sees how their relationship with the company works. And therefore, even though from a technical standpoint you can change many things about the employment relationship, as soon as you start it at one level, it's really only practical to go up in the United States. It's really only practical to give more benefits rather than less benefits. And so it's not the same. The same expectations aren't that way in every single country, but in the United States, it's very clear that people don't like things that are taken away from them after given to them in an employment relationship, and they're willing to leave just based on principle because of it.